You go, Judge.
All right, thank you. All right, everyone, we're going to go live. Just give me a moment. Let me set us up.
You're good. You can share mine. Unless we can share that. Share that one if you do that. Share mine if you have this. So how long do these batteries actually last?
Yeah, they lie. Can you hear us? She's in her house. Oh. Okay. Okay, I'll push it off.
Oh, yeah. Yeah, you're right. Let's see. And then we have this is 7.
All right, everyone, we're almost there. Just give me 1 second.
Yesterday was really funny because you have Robert Garcia. No, I have some people. Robert
Okay.
Garcia, he was hiding behind Brenna.
Mhm.
And he's like, this is eating a Danish, just drinking coffee, thinking that he's hiding behind you.
Yeah,
And then
I
he
was trying to move my bed, but I couldn't.
No, somebody has their audio open.
Okay, why does this keep
And I
doing
turned
this?
the iPad on.
My mic is muted. Yeah.
Oh, it's Judge. Judge has her thing open. It's your audio's open.
Okay, let me do that.
Hey, Tim, I sent you a chat. If you don't mind, I have a question. Oh, you see it. Never mind. Thank you.
Thank you. All right, everyone, welcome back. Let's see. All right, are we ready to proceed? Is there anyone who is ready?
Judge Tim Molina, if I could go into a breakout room with Mr. Garcia and just walk
Just a
him.
moment. For some reason, we're not able to hear you all.
Oh, I know why. It's the.
You're all on mute too, as well.
What do you publish? Versus. All right, you should be able to hear now.
All right,
Okay.
Tim Molina.
Yeah, I need to go into a breakout room really quickly with Jose Garcia to have him sign the video waiver and just walk him through the hearing process. It'll be about 5 minutes.
All right, Mr. Garcia, if you go to breakout room number 2 and Mr. Molina, number 2. All right, Robert Wilson.
Yes, Your Honor.
Yes.
I have 3 motions that I filed this week. One is for the black box data of the car that was in the collision for the incident, the basis of our suit.
Well, that has been signed by the court. The state said they had no objections to that motion.
And they've already, on the blood test draw, they've already sent that order out, and assuming that you would sign it, then I'm assuming they have no objection to that as well, because they've already done some work. Hunter's here. He sent it out.
All right, just one moment. To the clerks, could you bring the files from my office to the courtroom, please?
Yes, Judge.
Thank you. And does anyone know, Mr. Wilson, what is your client's name?
His name is Francis Barnett, and he's here online.
He's on the add-on, Judge.
All right, thank you. All right, so the state has agreed to the discovery as it relates, you said, to the blood draw?
Yes, Your Honor.
All right, is there anything else you need?
I had asked for a continuance today, but I guess I don't understand. Are we on the jury trial docket, or because I'm still
No,
trying?
you're here today for motions.
Okay, so we have a motion for continuance as to the final trial, because we want to get this data before final trial. We're set for the 6th, but I'm being told that that might be a pre-trial final plea deal hearing.
No, the jury trial date is for August 6th. So
Okay.
what will end up happening is you can come in on August 6th and we'll see where we are with you obtaining whatever you said you have not obtained.
Okay. All right, and I understand that we have passed your plea bargain date, but I continue in good faith to work with Mr. Hunter in the ADAs in the hopes that we can find a solution to this to our case.
All
I
right,
know
well, with
that
regards to plea deadline dates,
Yes, sir. Yes, ma'am.
if the defense and the state are asking the court to extend a plea bargain deadline date, then there will need to be a good cause or good reason for the court to extend that date.
Okay, I'll file that in a motion for it to be heard on August the 6th, if that's
All right.
okay with you.
Yes, we'll see
And
you
we'll-
back on August 6th.
And we'll rehear my motion for continuance on that date.
Yes.
Thank you, Your Honor. May we be excused?
Yes, unless you have anything else with us. Norma, is there anything else for Mr. Barnett?
No, ma'am.
All right, we'll see you August 6th then.
Thank you.
You're welcome. All right, Mr. May.
Good afternoon, Your Honor. Here on Mr. Rodolfo Lopez.
Charles May.
Yes, Judge. Can you hear me?
Yes, I can hear you now. Who did you have?
I'm sorry, Mr. Rodolfo Lopez, Judge.
All right,
Just
got
got-
it confirmed.
If I could confer, I would appreciate it, Judge.
All right, I will send you to breakout room number 3.
Thank you, Your Honor.
You're welcome. All right, Mary Peterzak.
Yes, Judge. Good afternoon.
Good afternoon.
If I could go into a breakout room with Mr. Hernandez, I have some paperwork to go over with him.
All right, Mr. Hernandez, I'm going to send you to breakout room number 4. Who were you doing paperwork with on that case?
Oh, David Martin?
Okay. All right, and does Ms. Ferguson have, I'm assuming she has his information because he's in custody.
Yes, I believe so. I think
Yes, ma'am, I have it. I'm working on it right now.
All right, if you go to breakout room number 4, then Ms. Peterzak.
yes, Judge. On
All
my
right, Joe Stenberg.
Howdy, Manuel Gutierrez. Could I be put in a breakout room with Meredith McIntyre, please?
All right, just one moment. I'll send you to breakout room number 5.
Thank you.
You're welcome. And everyone, just give me one moment, please.
That's what I said. I was trying- I took that person. It's out loud. Okay. So I argued that was enough. Yeah. But we can-
And Mr. Lopez, your attorney is actually conferring with someone from the state. When they want you in the breakout room, they will request you. All
Yes,
right,
ma'am.
Tim Molina, are you ready on your client?
We are ready, Your Honor. Oh, you know what? I'm sorry. I didn't get the video waiver signed. We talked through the procedure, but I'll need to get him to get a guard to help him sign the document.
All right, if you go to breakout room number 1,
Okay.
Mr. Molina, and then we'll take you up as soon as you're back in the main room.
Okay. And then I think he came in here too. So is he going to get directed in there too?
Yes, he is. Excuse me, guard. Mr. Garcia.
How you doing,
Hi,
man?
Hello, officer, he just needs to sign some paperwork. It should be a consent to appear by video.
Okay, ma'am. Well,
All right.
let's see, go on this real quick. Take the last name in, sir. Garcia. Garcia. What's your first name? Jose.
Asked all of them to say-
Tim, there's a guard there, so I'm just having him remain in the main room.
Like, it goes off too.
Take the name in, sir.
No, I mean, that's-
That is done, ma'am.
Unless somebody
Thank you.
walks in.
Who is the prosecutor who's taking this case
See what it is.
on Mr. Garcia?
It was negotiated with Marcus Sanders, and then I believe Ms. McIntyre just asked me what the deal was through the chat. So I guess maybe she's handling it.
All right, just one moment. And what is your client's full name, please? Mr. Molina.
Jose Luis Garcia.
All right, and is this cause number 2021 CR 2778?
No. It's he has a new case that they're going to dismiss, but not as part of this deal because it's not alleged in the MTR. This is an MTR on 2020 CR 4194.
All right, to the clerks in the back, could I have that cause number, please?
Yes, Judge, we're coming in. I'll be right there, Judge.
Thank you. Mr. Molina, what is the agreement on this case?
True to violation 19, deny alternate amend to stay in jail until a bed's available at something called T-Comp, which is my understanding used to be called MyOut, that he's already been evaluated for and approved for.
All right.
PM, 6 PM, somewhere in the range of 86, 87. One day. 92% of the animals on my touch. 86, 87. Thanks for more pleasant traffic.
Thank you. And Hunter, are you able to take this plea on a motion to revoke? It's a plea of true to violation of condition number 19.
19, okay, Judge. Sure.
All right,
And
thank
what
you.
is the agreement?
It's to deny.
Are we amending?
Yes. And I'll put that into the record.
Okay, let me pull up the MTN.
Right, and could you show video, Norma? For the main room?
Oh, the main room?
Yes.
Yeah. I had to get an office after I had it on.
No problem. Oh, I'll just read it out, Hunter.
You sure, Judge? I don't mind reading it. I just don't know if I have to.
Oh, it's, I'll read it. The court is calling 2020 CR 4194, State of Texas versus Jose Luis Garcia. Can I have parties announced for the record for the state? For the defense?
Tim Molina for Mr. Garcia.
We're proceeding by video. Any objections from the state?
No, Judge.
Any objections from the defense?
No, Your Honor.
Mr. Garcia, did you sign a document entitled Defendant's Consent to Appear by Video Conference? And did you review that document with your attorney?
Yes, yes, I did.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Showing you a document entitled Motion to Revoke Community Supervision. Did
Yes,
you review that document with your attorney and did you understand it?
Yes, ma'am. Yes, I did.
Are you the same Jose Luis Garcia who was placed on community supervision in 2020 CR 4194 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on August 3rd, 2020 for a period of 4 years? Is that you?
Yes, ma'am. It's me.
State is proceeding on violation of condition number 19. Is that correct, state?
That is correct, Judge.
The violation reads as follows. In Bexar County, Texas, the defendant Jose Luis Garcia did then and there fail to report to the supervision officer as directed in weekly Zoom meetings for the weeks of September 1st, 2020, September 7th, 2020, September 14th, 2020, September 28th, 2020, October 5th, 2020, October 12th, 2020, October 19th, 2020, October 26th, 2020, November 16th, 2020, November 30th, 2020, December 7th, 2020, December 14th, 2020, in violation of condition number 19. How do you plead to that, true or not true?
True.
State, are you waiving and abandoning the remaining allegations?
Yes, Judge.
Mr. Garcia, did you understand by pleading true to violation of condition number 19, the court could find it true, grant the motion, find you guilty, and sentence you to 4 years in prison and a $1,500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 19?
Yes, ma'am.
Court will find violation of condition number 19 true. It's the court understanding there's an agreement. Is that correct, state and defense?
Yes, Judge.
Yes, Your Honor.
And defense, what is that agreement?
That the court deny the MTR continue Mr. Garcia, alter and amend his conditions to include the lockdown facility that I believe is called T-Comp, or the old MyOff equivalent, and stay in jail until the bed is available.
All right, State, is that the agreement?
Yes, Judge, that is my understanding.
Mr. Garcia, are you asking the court to follow that agreement?
Yes, ma'am, please.
All right, then the court will follow your agreement. The court will deny the motion, alter and amend conditions to include TCOP. Mr. Garcia, you're going to remain in custody until you're transferred. However, I don't want us to lose track of you because I don't want you sitting at the jail for an exceptionally long time. So Ms. Ferguson, can you recall this case in 3 weeks just so we can get an update on where he is with the transfer? But don't put it in the system because, of course, if you put it in the system, that will stop his transfer.
Yes, ma'am.
Your Honor, I assume you mean the DDRF? I've never heard of TCOP. I don't know what that is.
Yes.
DDR, I'm sorry, that's what.
Okay.
The TCOP was the evaluation, I think.
Yes, the Tacoma, yes.
And the DDRF to be the MyOff equivalent.
Yes, it is the MyOff equivalent.
Okay,
So-
and I apologize because the verbiage is all changed. And so that was the agreement, DDR.
I want to make sure. Thank you.
All right. Norma, what date are we coming back?
I can bring it back on the 13th.
All right, we're going to come back on August 13th, Mr. Garcia, just to make sure that you're on schedule for transfer. If you're already transferred, then we will not see you on that day. Do you understand?
Yes, ma'am.
All right, Mr. Garcia, here's the thing. In order for probation to do their job, to help you where you need help, you have to communicate. It can't be a situation where you just don't show up. Do you understand?
Yes, ma'am. I said I got hurt. You know, I was coming home from work and I had got hit in the head, so I was in the hospital half that time.
He
Okay.
did have an explanation for missing. He did resume, but it was true that he did miss that chunk of time.
Yes, yes.
All right, I'm going to send you to a breakout room. Probation is going to go over conditions with you. Mr. Molina, you can go to a breakout room or either you can be excused. Mr. Garcia, I'm going to send you to breakout room number 2. And probation, if you will go to number 2 to go over conditions with him, please.
Okay.
Thank you, Judge.
You're welcome. Is there anyone else ready? We are starting up our jury trial at 2:30 exactly. So if there is no one else ready at this point in time, what's going to happen is we're going to resume our jury trial. And you will have to remain on screen and we'll take up your matter after testimony.
This is Joe Stenberg.
Yes.
We're back from a breakout room and Miss Meredith just received some information and she needs to confer with whoever's in charge of CIs and a detective who is retired.
Well, I think you may not want to mention that on the Zoom screen because we're live on YouTube. So what is the case?
My client's name is Gutierrez, first name Manuel.
When are we resetting Mr. Gutierrez? Are you asking for a reset?
Yes.
All right, so Norma, I'm sorry, Meredith, how much time do you need?
We can get a quick reset, Judge.
All right, Norma, can you recall this in 2 weeks?
Yes, ma'am. I can do August 12th, Judge.
All right, we'll see you back then on August 12th.
Thank you.
You're welcome, you're excused. And Mr. Garcia, you need to go to breakout room number 2.
I can't see it here, ma'am.
Norma, can you have a deputy help him go to number 2, please?
Yes, sir. Mr. West.
All right, Anton Hayek.
Present, Your Honor, my client should be here. I've sent him the Zoom link again. He said he signed the paperwork.
Who's your
That's
client?
Adrian Herrera.
He's not on the Zoom screen.
Oh, well, what else is new, Your Honor?
Each day is filled with.
Judge, can you move Mr. Mays in a breakout room with Mr. Lopez, please? L3.
Mr. Mays, if you go back to breakout room number 3, please.
Yes, Your Honor.
And Mr. Lopez, if you go to 3.
You got everything you need? Is there anything you're missing? No, I'm good.
Everyone, we're starting back up our jury trial. So I'm going to need everyone, I'm going to send you to a breakout room. And Meredith, I believe you have the ability to move throughout the breakout rooms. And David has the ability to move throughout the breakout rooms. And Norma, you have the ability to move people throughout the breakout room.
Thank you.
And
Okey
everyone
dokey.
else,
Oh, I just rewatched the entire series. I used to be Miss Jessica Walter. I loved her in Archer.
oh, I loved
She's
Archer.
like
Mr. May, we're starting a jury trial. You all need to return to your breakout rooms and wait until I come to remove you. So, Mr. Hernandez, you need to go back to your original breakout room. Ms. Peterzak, go back to your breakout room. Thank you. And Mr. Hernandez, if it'll help you, I'll just send you to a different breakout room. Where did Mr. Hernandez go? He's at number 10. I'll send him to number 4. Yes, you can bring it in. Oh, where's the witness? Oh, yeah, tell him to come on in. He can take a seat. And you need to remove your shades.
Oh, I'm sorry.
No problem.
Good evening, Judge.
Good evening. Guess we're ready.
All right, to the jury.
All right, everyone, please be seated. I hope everyone had a nice lunch. All right, if you can raise your right hand for me, please. And state this is your next witness, correct?
Yes, State Police Officer Maurice.
All right. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Please do not touch the microphone, but speak loudly so the court reporter can hear and the jurors can hear. If you could state your name for the record and spell it, please.
Officer Garrett Maurice, Garret. Last name is Maurice, Maurice.
All right, state.
Thank you, Judge. Officer, can you please tell the jury where you're currently employed?
Yes, sir. I'm employed with the San Antonio Police Department. I actually work West Patrol, which is on the west side of San Antonio.
And how long have you been with the police department?
5 years.
And I know officers wear many hats, but what are some of your typical duties while you're working?
So I'm a patrolman. My primary duty is calls for service.
And were you a patrolman back in 2018?
That's correct, sir.
Okay, and what type of special training do you have to become an officer?
We go through an extensive amount of training. The academy is roughly, I say, 30 weeks long. Once you graduate from the academy, you're actually deployed in the field. You go through an FTO program. It's a field training program. I'm actually a field training officer myself. Once you pass the field training program, you're actually put on probation for 6 months. And then after that, you're a solo patrolman.
So let's go back to 2018, specifically September 12th. Were you on patrol that day?
That's correct.
And were you involved in a call-in or incident with a male named Michael Hernandez?
That's correct.
And is he in the courtroom today?
Yes.
Can you please identify him by an article of clothing?
White long sleeve shirt.
And for the record, the witness has identified the defendant. And officer, let's kind of go in chronological order. How did you first become involved with the defendant?
I was dispatched to the target.
And do you remember where the target was located?
Alamo Ranch area, which is 1604 in Clayville, Cross Streets.
And is that in Bear County?
That's correct.
And so what happened? You were dispatched there, you drove there. What happened when you first arrived to target?
Yeah, I was dispatched there for shoplifter call. The defendant was already in the loss prevention room with the staff. Went inside the room with the defendant and the staff. Started conducting an investigation to determine what offense was committed, if one was committed.
And what did you learn based off that investigation and speaking with the staff?
That a theft was committed.
Okay, and once you learned that, what happened?
After that, the defendant was placed under arrest
For what offense?
for theft.
And he was placed under arrest. Did you transport him or what happened?
Yeah, from the target, I was the arresting officer and the transporting officer, so we relocated to the central magistrate.
Okay, and during that time, were you wearing a body cam or any type of camera on yourself?
I was.
Okay, and do you know if that camera was working during that time?
It was.
And did you review that camera?
I did.
May I approach the witness, Your Honor?
Yes.
I'm showing you what has been pre-marked as State's Exhibit 7. Do you recognize this?
Yes, sir.
And how do you recognize this?
My name and badge number.
And have you viewed it?
I did.
And what is on this disc?
My body cam from the inside.
And to your knowledge, has it been tampered with or altered in any way?
No, sir.
Does it accurately represent what happened that day?
Yes, sir.
Your Honor, at this time, I'm showing defense State Exhibit 7 for any objections and offer State Exhibit 7 into evidence.
Any objections?
Yes, I'm not quite sure. For authentication purposes, did you?
Would you like to take the witness on voir dire?
Yes, Judge, please.
All right, you may ask your questions.
For authentication purposes, officer, you did view this tape?
I did, sir.
Or excuse me, the recording?
Correct.
Okay, and it did accurately reflect what you saw that day?
It reflects on what I did that day.
Okay. No objection, Your Honor.
All right. Then State's Exhibit number 7 is admitted into evidence.
And for the record, the jury will have this for deliberation purposes, but what specifically does it show on the video?
It shows me arriving. It shows me speaking to the loss prevention staff. I actually have my laptop inside the small office with me. I run the defendant's name. After we determined that an offense was committed, theft was committed, he was placed in handcuffs. He was searched there, and then we exited the target. We got into the patrol car and then went straight to the magistrate.
So during your investigation and while you're talking to the staff, did the defendant mention to you anything about having a broken cart or having a cart with a broken wheel?
Not that I recall.
Objection, Your Honor. That calls for hearsay.
Want to be overruled?
Not that you recall.
Not that I recall, sir.
Okay. And after your investigation, is it in your opinion that a theft was committed?
That's correct.
And is that why you placed him under arrest during that time?
That's correct, sir.
Thank you. No further questions.
Defense?
Yes, officer. When you arrived, Mr. Hernandez, you stated previously that Mr. Hernandez was in the office at Target. Is that correct?
That's correct.
Okay, so you did not see with your untrammeled eye anything other than Mr. Hernandez in that office. Is that correct?
you'd have to repeat the question.
Okay. You did not see Mr. Hernandez in any other occasion on that day other than in that office?
That's correct.
Okay. So you did arrest him for theft, but you didn't actually see anything, did you? With your untrammeled eye, actually at all, you just saw Mr. Hernandez in the office, is that correct?
Yes, sir, that'd be correct.
No more questions, Your Honor.
State?
No further questions from the state judge. May this witness be excused?
All right, is this witness excused or subject for recall?
Yes, subject to recall, Judge.
All right, the rule has been invoked. What that means is you cannot discuss your testimony with anyone. Only persons you're allowed to speak to are attorneys for the state or attorneys for the defense. And if you could remain in the vicinity, because one or more parties may ask for you to return to the witness stand. Okay. State, call your next witness, please.
Stay arrest.
Defense.
Defense rest.
State.
Stay arrest and closes.
Defense.
Closing, Your Honor.
All right, ladies and gentlemen of the jury, we have a couple of matters to take outside of your presence. So again, you've heard some evidence. You are not allowed to deliberate until I give you instructions to begin deliberation. So I anticipate on bringing you back out here, hopefully by, let's say 3:25. And then you will get a chance for me to read to you what's called the jury charge, and you'll hear closing arguments from both the state and the defense. All right, if everyone will please rise for the jury, please. All right, everyone can be seated. Ron, did you, and I'm going to go on mute for a moment on YouTube. Did you receive a copy of the jury charges? Not what I can do is I'll just print it out, what Julie has proposed.
Yes, I have not received a copy of the jury charge.
All right, I'll just print it out here for both parties.
Judge, two things. I have reviewed what Ms. Julie sent in the most recent email that this court forwarded. That will need to be modified. I believe that charge at that point was under the impression that the defendant was going to testify.
Yes.
So that language will probably be added again. Also, may the witnesses be excused at this point.
That's no objection by the defense. If the witness.
All right. Yes, excuse.
Thank you.
All right, if everyone can make sure that you go back to hiding your video for me, please. If you're not a part of this hearing. Okay, and then. And Julie, if you can hide your video for me for a moment, please. And Deputy Laura, I need the video for the 187 DC. All right, Julie, we're gonna take up one other matter. You can either hide your video or stay on video. All right, we're gonna go back on the record. And clause number 2019 CR 13789. This is outside the presence of the jury. Defense, it supports understanding that you have an argument to make or something you want to present it to the court.
Yes, Judge.
Yes, you may proceed.
Yes, Judge. Motion for directed verdict, Judge.
On what basis?
Lack of reasonable, lack of probable cause, and in addition, lack of reasonable doubt. Beyond a reasonable doubt. Lack of evidence.
All right. State.
Thank you, Judge. I believe this would have been timely urged prior to defense closing, but the state has proven with James Loeffler and Officer Garrett Maurice each element more than a mere scintilla of evidence for each element, such that a reasonable jury could find this defendant guilty beyond a reasonable doubt of the offense as charged. On or about September 12, 2018, both witnesses testified to that date. There is evidence submitted to this court and before the jury that have the timestamps that include that date. In Bexar County, Texas, both witnesses testified to the location being in San Antonio, Bexar County, Texas. Both witnesses identified as defendant. Without consent, Mr. Loeffler testified that he did not have permission to take those items without paying for them at Target. Target being the victim. Unlawfully appropriated property that was also established through Mr. James Loeffler. And with intent, there's plenty of evidence provided by Mr. Loeffler, the behavior, the circumstances, and the video that show that this defendant did have the intent to deprive. And then the defendant stipulated for the two prior convictions. So the state would urge this court to present this case to the jury.
All right, motion is untimely. However, the court will allow defense to present its motion, which the defense has presented, and the court will deny the defense's motion. Is there anything else?
Nothing from the state judge.
Nothing from the defense judge.
All right, all right. And we will go back to the main view. And defense, if you, once you review the jury charge and you're ready to argue on the jury charge, or if you think the jury charge is appropriate, just let the court know.
All right, Judge, I will inform the court as to when I am finished reviewing the charge.
Yes, thank you.
I will try to do it as expeditiously as possible.
No, take your time. All right, is there anyone else ready?
Judge, do you want me to bring everybody back from the breakout room?
Yes, please.
Yes, ma'am.
Sorry, I realized that I was like taking on.
I was like,
Wait,
what?
I think you realized it. No, I looked at her.
I was like, bring it down.
I hope not. No, he bought it. So what's it? It's a thing. Okay, let's take care of this.
Yes, Mr. Anton Hayek. Has your client made an appearance?
He is working on it, Judge. He told me that he was out of town and had bad reception, was heading back towards us. I just texted him to try and get on now.
All right.
I guess the correct answer is no, he hadn't made an appearance,
All right.
but he wants to.
We are of course here till 5, but what I can say is this was the issue when we were here last time, that he's constantly making his way back and there's bad reception. So if he doesn't appear by 5, then something else will be done to help him.
That's fair. It's okay. I understand it.
All right.
Judge, I do show he's signed the paperwork for what it's worth, but obviously he needs to appear, so.
Let me go hustle after me.
All right. Thank you, Mr. Hyatt. Yes. What I'll do is I'll put them there. Oh, we have it. I think we did here. We did hear Tim Molina's client.
That one I have already. Oh, no. Are they still there?
Yes, it should
Okay.
be. Was that Jose? Yes. Okay. Did I give you the file back? Because it's not. This was the one.
You know, I'm not
Oh, yes, or either Docket or Bexar. But that's the other
The other
one.
one, right?
That I assume the state was taking that into consideration. Meredith, are you there?
Yes, Judge.
Was 2021 CR 2778 Jose Luis Garcia, was that being taken in consideration or no?
Yes.
Okay.
That's what Marcus said.
All right, thank you. All right, thank you. Yes, if you could bring me out, please. Yes. Mr. Zimmerman, are you still reviewing the report?
Yes, I finished reviewing the charge. Your Honor.
All right, is there going to be any objection to it?
Yes, there's going to be objection to section number 3.
All right, just one moment. Let me look at section number 3. State, have you had a chance to review section number 3 of the?
I'm going back up section 3 now, Judge. Oh, it's aggregate language. I have no problem.
Let me just print this for me because it's easier for me to read it in print.
Section number 3, Judge, to my understanding, is just aggregate language.
Yes.
And this is not an aggregate allegation.
All right, let me look at that. Ms. Patterson?
Judge, you want me to take out number 3?
Yes, just one moment.
I don't have any problem with the.
All right, the state has said The state has said they have no objections to removal number 3. Is that correct?
Correct, Judge. It seems to me just to be aggregate image.
Okay. All right, so Ms. Patterson, if you could remove number 3.
Okay. Anything else?
Anything else, Mr. Zimmerman?
Not at this point, Your Honor.
All right, no, she's going to make the charge now, so there's nothing else.
There's nothing else.
All right, so Julie, if you could just add the language about Mr. Hernandez not testifying,
Yes.
and then if you'll email that to me, I'll make sure that both parties have it.
Sounds good. Thank you, Judge.
All right, thank you. So everyone just give us a moment and we'll get that for you. All right, are the parties ready on Zane Hernandez?
Mary Petrashek here, Judge. We're ready.
And who is the prosecutor?
I was working with Mr. Martin.
All right, David Martin, are you there? If you could show your video. Oh, there he is. All right, the court is calling 2021 CR 4791, State of Texas versus Zane Hernandez. Can I have parties announced for the record for the state,
David Martin.
for the defense?
Mary Petrashek for the defense, Judge. We're ready to proceed.
All right, and are you Zane Hernandez?
Yes.
We're proceeding by video. Any objection from the state?
No objection.
Any objection from the defense?
No objections.
Mr. Hernandez, I'm going to show you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm going to show you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Hernandez, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, we are.
Mr. Hernandez, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review this document with your attorney? Did you understand it and did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, there's an affirmative finding of deadly weapon. The state recommends deferred adjudication. They will take in consideration 2021 CR 6386, County Court Cause number 629930, 629931, 652780, grand jury number 739692. There's an affirmative finding of family violence, anger management, TAP evaluation, McMilf evaluation, no harmful or injurious contact with Sergio Garcia and Felix Huizar, Huizar, and defendant is to forfeit the Smith & Wesson 9mm seized under, and then that was cut off. Seized under what?
It's going to be case number 652780 out of County Court 2.
Did you understand that to be the plea bargain agreement, Mr. Hernandez?
Yes, ma'am.
State, is that the plea bargain agreement?
Yes.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Judge.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 5 years. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in an indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's no contest plea.
I'll offer states one and its applicants.
Any objections?
No objections, Judge.
Mr. Hernandez, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call on, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
All right, we're going to go off the record for a moment. Could you stop sound, please? All right, we're back on the record. All right, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept evidence, step into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing or no?
Yes, Judge, we'll waive the PSI and proceed with sentencing today.
All right, anything you wish to say on behalf of your client?
No, Judge, I think that there's everything in the report for you. This was a isolated incident with his family members, and I think that perhaps some treatment through whatever the TAP evaluation is going to say is going to give him a good foundation.
All right, Mr. Hernandez, could you unmute yourself, please?
Yes, sir.
All right, Mr. Hernandez, what were the issues that night? Do you have drug issues, mental health issues? What's going on?
There's just an argument going on. There's just mental issue. Nothing else wrong.
All right, what is the medical issue?
Just the anger management.
All right, that's not a medical issue per se.
Oh no, not that. I'm sorry.
All right, so it's more than an argument because what I've read is that you wanted to stab your grandfather. And obviously your grandfather is letting you live there. So have you ever used drugs before? All right, so here's the thing, Mr. Hernandez, I'm gonna need you to be honest with me because when I place people on probation, be it deferred or regular probation, I want them to be successful. If I didn't think you could be successful, I would not follow this agreement. But in order for you to be successful, I need you to be truthful with me so that I'll know what conditions you need in order to be successful. So what type of drugs have you used in the past?
There's no one. There's nothing more. Of course, is that you live there, so that would I try stabbing you.
Okay, we're having problems hearing you. Could you maybe lower the microphone a little bit? Yes.
Well, I would use marijuana and well, why would I try stabbing him with the circumstances of him letting me live there with him?
All right, you can't make out what you're saying. Is there anyone else in the room with you there?
No.
No, just no one near you, correct? Could you lower your mask a little bit for me? All right, speak now, please.
Well, I was just using marijuana and why would I try to do anything to let me live there under his circumstances, if anything?
Okay, how far did you go in school?
So I graduated.
All right, so what have you been doing with your life other than living on your grandfather's property?
Working.
Where have you been working?
Works mechanical.
Doing what?
AC.
I don't know what you're saying. I think there's a problem with your microphone. Lower, move the microphone from your mouth. Just lower it.
Okay.
Now say something for us, please.
Can you hear me?
Yes, that's better. All right, so where do you work? Or have
Boats Mechanical.
Sports Academy?
Boats Mechanical. It's a AC company.
Okay. So why do we think he needs a McMouth evaluation? Has he had any mental health issues in the past? Or do we just not know because something may have went wrong that day?
Yeah, we're not sure. According to the victim, he was either under the influence of drugs that day, or there was some mental health issue because he was definitely not acting like himself. So just to see which it was, I guess.
All right, this is what the court is going to do. Court is going to sentence you to 5 years deferred adjudication, affirmative finding of deadly weapon, taking consideration the following cause numbers: 2021 CR 6386, County Court cause numbers 629930, 629931, 652780, grand jury number 739692, anger management, McMouth evaluation, no harmful or injurious contact with Sergio Garcia, and Felix Weezar, forfeit all weapons. Do you have any children?
Oh, no.
Proof of employment within 30 days of release. No employment as a home health care provider or with minors. Are you able to Zoom, Mr. Hernandez?
Would a phone work?
Yes. Are you able to appear through Zoom, through video? Are you able to do that?
Yes, ma'am.
All right, it'll be regular Zoom recording. If you can't do that, then you have to report in person. Random UAs. And I'm gonna want random field visits 2 times per month. Mr. Hernandez, is there anything else you need from the court to be successful?
What if can I transfer address for probation?
I think
Transfer where?
Mr. Hernandez wants the opportunity to potentially move out of state at some point. He doesn't have an address currently.
All right, transfer where?
To California.
Where are you going to be living in California?
Manhattan.
But where's this location? What city? What county?
I just know San Francisco.
All right, once you've been approved, and when I say approved, I mean once your aunt has consented to you living with her, because I don't have any information from that. Probation doesn't have any information from that. And it's going to require time if your probation were transferred there. Once you obtain all that information, then the court will, of course, if you're accepted, allow you to transfer to somewhere else. But for now, you'll be on probation in Bexar County, Texas. Do you understand?
That's right.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
That's right.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, Mr. Hernandez, you need to stay in communication with probation so we can figure out what's going on in your world, okay?
Yes, ma'am.
All right, I'm going to send you to a breakout room. Probation will meet you there. I'm going to send you to breakout room number 2. And Ms. Peterzak, you can go to number 2, or either you can be excused. And David, Charles May needs to speak with you. I'm gonna send him to breakout room number 4. And David Martin, if you could go to 4. Anton Hayek,
Present, and my clients is supposed to be here someplace.
is this your client LG
Probably.
Silo?
Probably. And Adrian, is that you?
Yes, sir. My phone just keeps disconnecting and reconnecting. I'm having poor signal where I'm at.
Well, here's the thing, from here on out, Mr.
Herrera?
Herrera, if you have trouble zooming in, you're gonna have to appear in person. We're not gonna do this thing where we're waiting for you because something's not working with your phone. Do you understand?
Yes, Your Honor. I completely understand. I'm sorry about that.
No, I'm just letting you know what the situation is gonna be from here on out.
Of
All right, what
course.
are we doing with Mr. Herrera?
The plea for deferred, Your Honor. We have an agreement.
All right, well,
Paperwork's been signed.
do they have all the paperwork? Has he signed everything?
That's what Norma
Yes, Your
said,
Honor.
yes.
All right, has it been sworn in, Ms. Ferguson?
No, we haven't received the court's paperwork yet, Judge. We just need the court's paperwork, like the video consent.
I haven't sworn him in yet, Judge, but I can swear him in right now in the breakout room.
Yes, I'll send you all to a breakout room. We're gonna bring the jury in at 3:35 for closing arguments.
Okay.
And I haven't received any paperwork. So I'll send you all to breakout room number 1. And Mr. Hayek, I'll send you to number 1. And Robert, if you can go to number 1. Mr. May,
Thank you, Judge.
Yes, Your Honor. If I could visit with my client real fast, I think we got it worked out, Your Honor.
all right, and your client is in number 4, correct? I'm sorry, 3.
Three, I think, but
All right, Mr. Lopez, please go to breakout room number 5. Mr. May, go to number 5. Sometimes it's easier for people to move around when they see the number pop up. Yes.
thank you, Your Honor.
Judge, in 2019 CR 13789, the state has no objection to the proposed charge other than this particular copy is missing the verdict form.
Yeah. And I have that form with me. Let me see, our
Do you want
printer
mine?
ran out of paper.
I imagine it looks the same as the official.
Here,
I can give him mine.
This is fine. This looks good to me.
'Cause I won't read
Thank
it.
you. These copies have-
Mr. Herrera, I sent you to a breakout room. You need to go to that breakout room, number 1.
I do have one correction.
How do I go to the breakout room number 1, Your Honor?
Yeah, okay.
What phone are you on? Is it an Android or an iPhone?
iPhone. I mean Android.
All right, you need to go to your screen where it says more. Do you see that?
Yes, I see it.
Do you see where it says breakout room?
No, ma'am. See what says meeting settings.
Look at the bottom of your phone. Do you see breakout room anywhere on there?
No, I only see chat, meeting settings, disconnect audio, and raise hand.
Is it left upper corner?
I think it's on this corner. What is, before we go on the record, what is your issue? Difference? I mean, state, I'm sorry. What's your? your
Judge,
issue?
on the verdict form, may I first-
Yes.
just correcting the offense listed down here.
All right, Julie, are you still there? You can outside and talk with her until what the issue is.
Sure.
In defense of you, go outside with him, please.
Hey, Julie. The state didn't have any issues with the current form
left.
other than the verdict form itself.
You should see the option on your phone, Mr. Herrera. Do you see it?
It doesn't say not guilty, but on the guilty option, it just says felony offense theft. We'd like to change it to theft under 2,500 advance. And that's the only correction.
This never gets old.
It doesn't.
Ron, are you agree with that?
Sure.
I think
Yeah, that's accurate.
Alrighty. Thank you, ma'am. Bye. There are multiple avenues to a felony level theft, only one of which applies to this case.
Yeah, less than, yeah, felony. I like the deletion.
All right, we're gonna, so everyone, that's gonna be changed. Other than that, were there any other objections from either side?
Not from the state judge.
Not from the defense.
All right, we're gonna go on the record briefly. Barnett, if we could go on the record. We're back on the record in 2019 CR 13789, State of Texas versus Michael Stephen Hernandez. Can I have parties announced for the state?
Hunter Morris.
For the defense?
Ron Zimmerman.
All right, have both parties had a chance to review the document titled charge of the court? State?
Yes, Judge.
Defense?
Yes, Judge.
Any objections to the charge of the court? State?
Only that mentioned in the verdict form, Judge.
And that has been corrected, correct?
Yes, Judge.
No objection to the corrected form.
All right, then how much time does each side need for argument? State?
Judge, the state would like to split its time to initial and final. 15 minutes total would be sufficient.
All right, defense?
I would like a half hour.
I'll give each side 15 minutes. Of course, if someone goes over a little bit longer than 15 minutes, the court will.
15 to 20.
Yes. All right. All right, everyone, we're going to bring back the jury in at 3:35.
Thank you, Judge. Before the DUI law changed in instructions. You would do like the full instruction, right? Or yeah, when you have the information. And so it's like all this stuff you put on there. You can just like see the names and for it.
I'm a big believer in state.
I am a pretty quick writer, and I write everything out, so I usually stay on top of it, but you're fast. And Nicole Phillips is fast.
Yeah. Whenever I can think about it.
Sometimes hauling a bale of hay.
Well, I think it was always, it was like on the phone.
Except my wife said, that's not a very good bale of hay.
I'm saying those are the ones.
I remember
when I was still young and naive. Point two.
Anyway,
And I was
this beats.
like, we didn't. No, I gave Jack Kim. I didn't go and tell her. I was just like, heads up. Anything about this has happened today. I was like, big deal, but just in case you hear something, I don't should call off. Nothing.
All right, is there anyone who's ready before we start up with the jury trial? Anyone ready? Because the jury's coming in at 3:35. All right, and I will take that as a no. And Julie just sent in the last page. So let me print this last page and then we will be ready to resume. with closing arguments.
Mr. Herrera asked to come and listen.
Mhm. Okay, let's see here. All right, this is the last printing. Norma, I'm going to stop your video. All right, you can bring them in.
Tricia, Padilla,
Now, do you have everything set up properly, Brenda?
Oh, you want me to check the?
Yes.
I remember.
Just to see if we have it correctly.
Telling you that I see the president. It's super excited. He yelled at the jurors.
Was there a specific way you all wanted to split your time or no? Does anyone want a time in the morning?
I think it's also. Joe, right? What do you think?
Right, it's.
Okay.
It's just showing 187th district. But I think you might have a spotlighter.
Oh, yeah. There we go.
Okay, so
Let me see, I guess. Judge, if I could just get like a 1 minute one,
But how are you dividing up your time?
5 minutes on the baby ones.
So, because you're 15 minutes each, you speaking first. Okay,
So delayed.
so you want
Okay.
5 minutes?
I mean, yeah, 5 to 8 minutes, I won't go over 8.
Okay,
It's fixed.
all righty. Yeah, that's what it is.
All right, to the jury.
5 minute warning, please.
Sure. All right, everyone, please be seated. All right, ladies and gentlemen of the jury, I'm going to read to you what is entitled the charge of court. Members of the jury, the defendant, Michael Stephen Hernandez, stands charged by indictment with the felony offense of theft under $2,500 enhanced, alleged to have been committed on or about the 12th day of September 2018 in Bexar County, Texas. The defendant has pleaded not guilty. Our law provides that a person commits the offense of theft if he unlawfully appropriates property with intent to deprive the owner of property. The offense is a felony if the value of the property stolen is less than $2,500 and the defendant has been previously convicted 2 times of theft. Appropriation of property is unlawful if it is without the owner's effective consent. Appropriation and appropriate mean to acquire or otherwise exercise control over property other than real property. Property means tangible or intangible personal property or documents, including money that represents or embodies anything of value. Deprive means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value or enjoyment of the property is lost to the owner. Effective consent means assent in fact, whether expressed or apparent, and includes consent by a person legally authorized to act for the owner. Consent is not effective if induced by deception or coercion. Owner means a person who has title to the property possession of the property or a greater right to possession of the property than the person charged. 3, a person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. 4, the defendant, Michael Stephen Hernandez, has stipulated and admitted to having previously been convicted on the first day of May 2013 of the offense of theft under $1,500 enhanced and cause number 2013 CR 3890W in Bexar County, Texas. And Michael Stephen Hernandez has also stipulated and admitted to having previously been convicted on the 9th day of December 2014 to the offense of theft under $1,500 enhanced and cause number 2014 CR 2626 in Bexar County, Texas. Therefore, you will find that the defendant, Michael Stephen Hernandez, has twice previously been convicted of the offense of theft as alleged in the indictment. 5, with respect to the stipulation by the defendant to having been previously convicted 2 times of theft, you are instructed that such evidence cannot be considered by you as in any manner proving or tending to prove that the defendant committed theft on or about the 12th day of September 2018. 6, now if you unanimously find from the evidence beyond a reasonable doubt that on or about the 12th day of September 2018 in Bexar County, Texas, the defendant, Michael Stephen, just one moment, please. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 12th day of September 2018 in Bexar County, Texas, the defendant, Michael Stephen Hernandez, with the intent to deprive the owner, namely target of property, namely 1 air purifier and 6 clothing items, did unlawfully appropriate said property by acquiring or otherwise exercising control over said property being other than real property, which had a value of less than $2,500 without the effective consent of the owner, and that prior to the commission of the aforesaid offense, hereinafter called primary offense, the defendant, Michael Stephen Hernandez, was twice convicted of the offense theft as alleged in the indictment and stipulated by him, then you will find the defendant guilty of the felony offense of theft under $2,500 enhanced as charged in the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded a defendant. And in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. Written or recorded statements made by a witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can only send statements and reports received in evidence to the jury room. The grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in determining whether the defendant is guilty or not guilty. All persons are presumed to be innocent, and no person may be convicted of any offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you in these instructions, you will acquit him and say by your verdict, not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. Do not let bias, prejudice, or sympathy play any part in your deliberations. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, or computer, the internet or any internet service, or any text or instant messaging service, or any internet chat room, blog, or website to communicate with anyone any information about this case or to conduct any research about this case until I accept your verdict. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. But the law of the case you must receive from the court as contained in these instructions and be governed thereby. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication was or is intended. After argument of counsel, you will retire to the jury room, select your presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate form attached to this charge and signing his or her name as presiding juror. The forms are not intended to suggest to you what your verdict should be. Your sole duty at this time is to determine whether the defendant is guilty under the indictment in this cause and restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. If the jury wishes to communicate with the court, the presiding juror shall notify the bailiff. Any communication relative to the case must be written, prepared by the presiding juror, and shall be submitted to the court through the bailiff. Respectfully signed, Judge Stephanie Boyd, Judge of the 187th District Court, Bexar County, Texas. Verdict forms are attached. State, are you ready to proceed with your closing argument?
Yes, Judge.
You may proceed.
Judge, before we begin, may I approach just to turn on the share screen?
Yes.
Where you can't click it. And I just press finish.
No, publish. See the bottom?
Yes.
There you go.
Should work now. Okay. May I proceed?
Yes.
Thank you. Members of the jury, what this case is all about is the defendant's refusal to take responsibility for the crime he committed. This is as straightforward, open and shut, by the book case as you can get. We have proven each and every element beyond a reasonable doubt. The loss prevention officer got up on the stand. He told you that on September 12th, 2018 in Bexar County, the defendant, Michael Stephen Hernandez, committed theft against Target without their effective consent. He unlawfully or purposely took the property with the intent to deprive. And as you have an evidence back there with you that he stipulated to, he's been convicted of 2 enhanced felonies before. And you have those certified judgments with you back there in the deliberation room. This was no accident. And why I say that is if you remember during voir dire, during jury selection, the defense gave an example of a friend of his that picked up something small, put it in his pocket, walked past the security, walked past the alarm system, and thought, oh, I have something in my pocket. I forgot about this. That doesn't compare to this case. In this case, he walked around the store, took clothes on and off, and as the loss prevention officer stated, it was suspicious. They kept an eye on him. He gets the cart, he picks up around a $300 air purifier fan. He walks on over to the fruit, look at the video, he tries a little bit of it, then he walks straight past where you're supposed to pay. He walks straight past the alarm system, and then they catch him at the end. They're there waiting for him because they knew he was going to be there, stealing the item. Now, there was a little bit of talk by defense that there was a broken cart, and the only logical reason I could think that they're saying that is because, oh, I wanted to go switch out the carts, that the carts were back here behind the security system. Well, if you watch the video, the carts are right next to him before he passes those alarms. You don't pass a security system with hundreds of dollars in your cart without paying unless you're going to steal those items. This case is as straightforward as it can be. And also during jury selection, when Mr. Morris asked, can a corporation be a victim of theft? Everyone agreed, because that's obvious, right? A corporation can be a victim, and the reason they're a victim is because when you steal from these corporations, you affect the people living there. That trickles down to the workers that are there. And I was reading an article the other day about some major corporations in California that can't manage their theft problem. And what this resulted in is these major corporations having multiple stores closed down. They closed multiple stores.
Objection,
Now,
Your Honor, objection. This is, he's stating things that are not in evidence.
All right, I'll sustain.
what this is all about is we all agree that a corporation can be a victim. And this isn't going to affect the CEOs. That's common sense. It isn't going to affect the CFOs. It's going to affect the hard people working there that actually make the store run. That's why we hold people responsible for committing theft enhanced as a felony offense. Hold him responsible and find the defendant guilty. Thank you.
Defense?
So I may approach the jury?
Yes.
Thank you. Well, here we are. After a long day, here we are. I want to commend you all for taking your time and effort and to paying attention and giving your solemn oath to perform this duty. It's a patriotic duty. This is the highest, in my opinion, one of the highest forms of democracy. You are here to perform this function of our democracy. This is kind of like where the rubber meets the road. And you are protection for ordinary citizens. That's why we don't have trials where just one person makes a decision on guilt and innocence. We require in the state of Texas, for the most part, that 12 ordinary citizens make that decision as to guilt and innocence, because it is a very difficult thing to hold someone, to hold them to be in judgment of something. It's a difficult thing. You have to take it very, very seriously. They are the government and you are ordinary citizens. And it is your job to determine what the facts are, to weigh the facts, give weight to the facts, what's important, what's not, and to deliberate as to guilt or innocence. And we leave that determination here in Texas, as we do in most states, but here in Texas, we do that to allow ordinary citizens to make that decision, not the court, not the government. You are here. You are the final protection for the citizenry, for everyone. In fact, 240 years ago, James Madison said in Federalist 12, he said, if all people, I'm paraphrasing, if all people were angels, we wouldn't need government. But all people are not angels, so therefore we need government. The problem, and here's the crux of it, who makes up government? But people. And you're here to put a check on that. That is your job to determine guilt and innocence. So let's go over the facts. Target assumed that Michael was trying to steal their stuff, their property. They made that assumption. Is that true? Well, let's think about that. Normally, when you try to steal something, particularly out of a store, don't you try to conceal it? Don't you try to hide it so no one will see it? Did Michael try to do that? You saw in the video, he did not do that. He walked up to and near the entrance, but he did not actually leave the building, did he? He didn't leave the building. And so they're asking you to assume intent on his part to permanently deprive Target of their property. Target, as they said, a large corporation, and deprive them of their property. But that's just an assumption. And you are going to determine whether he actually had intent to do so. I submit that he didn't have intent to do so. He didn't even leave the building. Didn't even make it out to the sidewalk. Okay? Out to the parking lot. No, he remained in the building. Now they came up and stopped him, or at least they think they did. I don't know why he was out there. They made the assumption, but you have to assume beyond a reasonable doubt that he was trying to walk completely out, and that he was going to, and his intent was to permanently deprive Target, this large corporation, Target, of their property. Is that true? I don't know. I don't think so. But that's for you to decide. But they made that assumption. Is it true or not? I don't think so. He didn't actually leave the building, as I said, and he did not try to conceal. Those are the main. If you're not trying to conceal, then is there actual intent to deprive them of their property? Normally, when you think of someone who's shoplifting, that they're going to try to cover it up. They're going to try to not let anybody see what they're doing. Walking out of the store completely, out into the parking lot. Did he try to do that? No, he didn't try to conceal anything. There was talk of problems with the cart, and the state just said that, well, why didn't he try to use one of the other carts? I don't know, but we can't make that assumption. You have to use the evidence in front of you. and not make assumptions. Has anybody ever has had someone accuse them of something by making an assumption that they were trying to do something that they actually weren't, what was in their head? That's not fair. That's not right. I submit to you that Michael did not try to permanently deprive Target of their property. And they can make all the assumptions they want. But the facts are he didn't conceal and he didn't actually leave the building. Whether they stopped him or not, we don't know. Was he actually gonna walk outside and walk completely out? Or was he going to try to switch cars? We don't know. They don't know. Yet they're making an assumption about him. So I submit to you that in this particular case, Michael did not have the required intent to purposely and permanently deprive Target of their property. And I think you should vote that way or determine a verdict that way as well too. He is not guilty of the crime that they insist that he in fact did. He didn't do it. He did not have the intent to deprive them of their property. I leave you all on a late Friday afternoon, and hopefully that you will render a verdict of not guilty. Thank you.
State.
Thank you, Judge. If I could just have one moment to get this PowerPoint. Switch back. If it's court counsel, Judge, folks, the evidence is all you have. The evidence is all you need. The proof is in the pudding here. There's nothing hidden. There's no assumptions that need to be made. You have eyes, you have ears. You heard testimony, you've seen video. You have those things to look at. And you can see with your eyes what happened here. The defense would like you to believe, or lead you to believe, that Mr. Hernandez would rather, he was just taking the box out to the cart, maybe to dust it off. He was going to bring it back. But like Joe Ray said, there were no kids with him. He didn't accidentally put something in his pocket because his hands were full and he needed the hands to corral the kids as well as take care of a cart full of things at the checkout. He had 7 t-shirts and 1 Dyson. The Dyson fan that would have looked pretty unusual if he had tried to conceal it under his shirt. So what did he do? He walked out with it. Where did he walk out of it with? Not a normal entrance, the entrance where the carts go. Why did he walk out of that entrance? Because there's no traffic there. There's no carts, there's no foot traffic. It's an open door. I have a picture I want you to take a peek at. It's a snippet from one of the videos that we've submitted in this case in evidence. After I scroll through all these slides. But if you look carefully in the picture, you can actually see the point that he's going through the doors. And you can see that he's setting off the alarm sensor. And so I want to ask folks, at any point that any of you have been in stores, I want you to think about this to yourself. If you hear an alarm sensor, does anyone not jump? Is there anyone whose attention it does not catch? I can't imagine being in a store where I have been able to ignore or overlook something like that.
Objection, Your Honor. Again, facts not in evidence. There's no evidence presented by the state that there was an alarm that went off.
That'll be overruled.
All right, folks, if you look at your screens here, this is a snippet from the exhibit in evidence. You can see the illuminated alarm at the exit door. You can also see all the rows of carts that he could have chosen from if there was an issue. Folks, we talked about reasonableness, and we talked about the state's burden. It's not defined. I understand that it's challenging, but it's not crazy. It's beyond a reasonable doubt. Use your common sense. You're allowed to do that. You're people. James Loeffler has to use his common sense. Officer Garrett Maurice has to use his common sense. They have training, of course, but they have to use their common sense. And what does this look like to any reasonable person? It looks like a man who's trying to walk out of Target with a $300 Dyson fan and a few Astro shirts. That's what that looks like. It is unreasonable to think that he is walking out of that door choosing to disregard these 1, 2, 3, 4, 5 rows of perfectly nice, cool, clean carts sitting inside to instead go and switch it out with a nice warm one on a balmy September day. And to take that expensive item that most people wouldn't dare touch unless they're going straight to the checkout line, taking that past all points of sale through security and not even budging the moment the alarm triggers. Watch the video, folks. He meandered around, he acted suspicious, he was caught, he was stopped. The guy. You have the judgments. There's no mystery here. There's no smoking mirrors. And so when you get back there to choose a presiding juror, when you come to unanimous decision, folks, we've given you the evidence. Again, it's right there. Please look at it. This second section here is the section to fill out for guilty.
Ladies and gentlemen of the jury, we now have the court's permission to deliberate. The deputy will take you to the back. If the alternates, if you could remain in the courtroom, please. All right, everyone, please rise for the jury. All right, if everyone everyone please be seated. And if everyone on the Zoom screen, if you'll give the court a 5-minute break, I will be right back. All right, and the alternates, if I could see you in the back, please.
Good job on the light. Good job on the light.
With the sensor?
Yeah,
on the
yeah.
left. Okay, counsel? It's always regardless of
Oh.
how it comes back.
You're muted, Judge.
All right, Anton, who was the prosecutor you were working with?
That's that Morrison Hunter guy.
All right, Anton, I cannot hear
Oh,
you.
hold on.
Okay.
Oh, that's right, because they changed it.
Oh.
Yeah.
Okay, you guys are not expecting me to learn that, right?
Okay, talk to us.
All right, Anton, are you there now?
Done what? Yes, I think so.
Okay,
That's what I'm
awesome.
told. That's what I'm told.
Okay, we were having problems on this end with the volume. Who's the prosecutor you're working with?
It was Hunter.
All right, Meredith, are you able to stand in? Or David Martin, can you stand in?
Yeah, what are we doing?
It's going to be a plea.
Okay.
All right, thank you. All right, the court is calling 2021 CR 1484, State of Texas versus Adrian Herrera. Can I have parties announced for the record? For the state?
David Martin.
For the defense?
Anton High for Mr. Herrera.
Are you Adrian Herrera?
Yes, ma'am. Yes, Your Honor.
We're proceeding by video. Any objections from the state?
No objection.
Any objections from the defense?
None, Your Honor.
Mr.
None.
Herrera, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Showing you a document entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I believe I received it all and I have reviewed it, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Herrera, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney, and did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Waive the reading of the indictment.
State, it appears that you're proceeding on the indictment as presented. Is that correct?
Yes.
All right, Mr. Herrera, I'm going to show you what's entitled Court's Admonishment and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of evading arrest or detention with the vehicle? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor. I completely understand.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor. I am aware.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, I understand.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, Your Honor. I understand.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do so believe.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is and was.
Mr. Herrera, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor. I've been satisfied.
Are you a U.S. citizen?
Yes, I am a U.S. citizen.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that page with your attorney and did you understand it?
Yes, Your Honor, to my knowledge.
According to the plea bargain agreement, there's a $1,500 fine to be probated. State recommends deferred adjudication. They will take in consideration county court cause number 638-595, 638-597, and 639-599. There's to be restitution to Joaquin Marino and Belinda Marino and Jessica Espinoza, EESPINOSA, under the above dismissed causes. Did you understand that to be the plea bargain agreement, Mr. Herrera?
Yes, Your Honor, I understand.
Defense, is that the plea bargain agreement?
That's our agreement, Your Honor.
State, is that the plea bargain agreement?
Yes, it is.
Next, I'm showing you what's entitled waiver of appeal. Did you review that paragraph with your attorney and did you understand it?
Yes, Your Honor, we reviewed it and understand it.
And did you electronically sign it in both places?
Yes, Your Honor, to my knowledge, I signed everything.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I understand.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 4 years. There be a TAP evaluation, 150 hours of community service restitution, and the driver's safety course and MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
I understand.
Then to the offenses charged in indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's guilty plea.
Offer states one in the attachments.
No objections, Your Honor.
Mr. Herrera, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
To my knowledge, I signed everything in the appropriate places, Your Honor. And yes, I reviewed it with my attorney.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witness the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, I understand.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Well, this is a moment of vast indiscretion where he lost control of his vehicle and kept on going. But he's going to get to pay a fair amount of restitution subrogation, Your Honor, because the car did not have insurance.
All right.
He now has his first child. I think he's growing up a lot.
All right, Mr. Herrera, how old are you?
I'm 19, Your Honor.
All right, how far did you go in school?
I went all the way to my high school diploma and I'm working on my associate's degree.
All right. what are you trying to get your, or working towards getting your degree in?
My associate's degree, since I'm gonna take advantage of the FAFSA that my school has to offer, I'm gonna try to route it as close as I can to anywhere with construction and construction managing.
Okay. Your defense counsel says you have a child on the way or have a child?
Yes, Your Honor, my daughter was born last month on the 17th. She was diagnosed with hydrocephalus, so that's another thing that I've been dealing with. And I feel like ever since she's been brought into this life, it's been a blessing for me, and it's clearly opened my eyes a lot.
Okay. So here's the thing, Mr. Herrera. When you have an accident, you need to stop, because then what ends up happening, the accident turns into being more, right?
Correct,
So
just like domino theory.
Given information, and whatever happens, happens, because you can't run away from your problems. When you stop running, they're always going to be there. And at some point, you're going to get tired. So your problems are going to be right there. You understand?
I completely understand. I'm tired of running, and I'm tired of always looking over my shoulders and watching my back. And that's why I'm confronting everything right now. And I hired my attorney.
All right. And if you're drug tested, what are the results going to be?
I'm hoping they're going to be clean on everything, but there might be a possibility of a low percentage of marijuana.
All right. So while you're on probation, you're not allowed to use drugs. You understand? So that means no alcohol, because under probation guidelines, alcohol is considered a substance. So you're not allowed to drink alcohol, and definitely no marijuana. You understand?
I completely understand.
And you're currently employed or no?
Yes, ma'am.
And what do? Are you doing construction at this time or no?
Yes, I recently branched off and started off on my own as a subcontractor, and I do cornice, I do siding on the outside of a house, anything that has to do with the outside of a house.
Okay. All right. So this is what I'm going to do. I'm going to send you to 4 years deferred adjudication. Hopefully that'll give you enough time to pay off whatever restitution you owe. And Mr. Hyatt, if there's a question about restitution, you think the restitution is not an appropriate amount, be sure to set that for the court to have a hearing on the amount of restitution.
I certainly will, Your Honor.
Thank you. $1,500 fine, that'll be probated. Take in consideration county court cause number 638-595, 638-597, 639-599, 150 hours of community service restitution. That'll be waived if you obtain some form of higher level of education. So if you get your associate's degree, I'll waive those fees. Or if you complete some sort of trade school, whether or not you have to do the restitution is completely up to you. There's to be restitution to Joaquin Marino, Belina Marino, Jessica Espinoza, the driver's safety course, and the MRT, employment within 30 days, no employment as a home healthcare provider or employment involving minors. That may change after you've proven to the court that you can be successful on probation. I'll do regular Zoom reporting, but Mr. Herrera, if you're unable to Zoom, you're gonna have to report in person. And I'll do regular UAs, or you can do the patch. Probation will explain to you the benefits of the patch. Patch is sort of cost prohibitive, but that'll be completely up to you which one you want to do. And I'll do a random field visit one time per month. Is there anything else that you need from the court, Mr. Herrera, in order to be successful?
No, Your Honor, just like you said, if I could accomplish this next degree in school, I would really appreciate those 150 hours waived, because like I said, I work a full-time job, and when I get of course, I have another full-time job taking care of my daughter.
Sure. I mean, you know, that's going to be completely up to you. If you can obtain your associate's degree, then it'll be waived.
Of course. I agree.
You are. I want to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
To my knowledge, yes, ma'am.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, with that, we'll close the record. Mr. Herrera, congratulations on your daughter being born, but remember, everything that she does is going to be her imitating you. So when children learn how to speak, if the first words they speak are profanity, it's because that's what the parents are doing. So you want to be a father she can look up to, okay?
Of course.
All right, I'm going to send you to breakout room number 2. It should pop up on your screen. Mr. Hayek, I'll send you to number 2.
Thank you.
And then you are excused. And Kevin.
Thank you.
Go to number 2, please.
Judge, who was that last restitution to? I heard something Espinoza, but I didn't hear the first name.
Oh, just 1 second, I'll give it to you. It is Jessica Espinoza.
Jessica, okay.
All right.
And the other one was Belinda Moreno. Okay.
Belinda Moreno.
Yeah.
And Joaquin Moreno.
Hey, Alex, David Martin. Just trying to get these photos open.
All right, Mr. Herrera, if you can go to the breakout room, please. All right, Norma, do you know what is happening with Mr. May and his client?
Yes, ma'am. I think Robert's on his way to give you the paperwork, Judge.
All right, thank you.
Yes, it's on an MTR, Judge.
Okay. And is there an agreement?
Yes, ma'am.
All right, and I am signing that document now, so it should be going back to them.
I think we bypassed you, Judge.
Okay. All right, Charles May, are you ready?
Yes, Your Honor. I think it says host has stopped video. I tried to turn on.
Yes, I stopped the video because we're in trial,
Yes, Your Honor.
but I'll ask you to start it now.
Okay, thank you, Your Honor.
All right, who's the prosecutor on Lopez?
Should be Mr. Martin, Your Honor.
All right, David Martin, are you ready?
Yeah, Judge, I'm handling a computer issue right now. It'll take a second.
All right, is there an agreement, David?
Yes, it's to revoke in 9 months in the state jail.
All right, Hunter or Joe Ray, are you able to take this plea?
Yes, I can take it, Judge. I don't have the condition.
Oh, I'll read it. What number allegation are you all going on?
Number 1, Your Honor.
All right, and you heard what the agreement was for the time?
What did David say, Judge? I didn't hear.
What time, Charles May?
I'm sorry, Your Honor.
9 months.
9 months, yes, Your Honor.
Okay. All right, the court is calling 2017 CR 11887, State of Texas versus Rodolfo Nicholas Lopez. Could I have parties announced for the record, please, for the state?
Joe Ray Garcia.
For the defense?
Charles Mays for Mr. Lopez, Your Honor.
And are you Mr. Lopez? Mr. Lopez, could you unmute for me, please?
Yes, ma'am.
All right, we're proceeding by video. Any objection from the state?
No, Your Honor.
Any objection from the defense?
None, Your Honor.
Mr. Lopez, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Mr. Martin, is your video working now?
Yes.
All right, then Mr. David Martin, I believe, is substituting in for Joe Ray Garcia. Is that correct?
Yes.
Mr. Lopez, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney and did you understand it?
Yes, Your Honor.
Are you the same Rodolfo Lopez Jr. who was placed on deferred adjudication in 2017 CR 11887 for the offense of endangering a child on June 19, 2018 for a period of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Condition 1, on or about the 24th day of January 2021, in Bexar County, Texas, the defendant Rodolfo Lopez Jr. committed the offense of assault in violation of condition number 1.
How do you plead to that, true or not true?
True.
State.
We'll waive the other allegation.
Any objections to the state's waivers?
None, Your Honor.
Mr. Lopez, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing this, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there an agreement?
There is just to grant the motion, enter adjudication of guilt, revoke community supervision, and sentenced to 9 months in the state jail facility.
Is that the agreement?
That is our understanding, Your Honor.
Mr. Lopez, are you asking the court to follow that plea bargain agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, then the court will follow your agreement. The court will grant the motion, find you guilty, sentence you to 9 months in the state jail facility, give you credit for any time served. Next, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney and did you understand it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
All right, if there's nothing else, we'll go off the record. Mr. Lopez, you have a
Yes, sir.
choice to make in your life. Either you're going to spend your life in and out of prison, in which case you will end up being the grandfather at the prison. When people come into prison and they want to know how the ropes are, they'll say, oh, ask grandfather Lopez. Or either you're going to get your life together and make the necessary changes so you won't end up in and out of prison. Do you understand?
Yes, Your Honor.
All right.
Could I say something, Your Honor?
What exactly do you wish to say?
Honestly, with everything going on, I actually did end up getting, my act together actually on the August 5th. I was starting school at Paul Mitchell, for School of Cosmetology for a barber license. And as well, I just purchased my vehicle and also as well paid off all my child support that I owed in back pay, which is close to $5,000. So slowly but surely I was actually getting, everything in order. But this is, I guess, because it's been a cloud looming over me for a while now. So this is the only way I could get it past me. So this is why I went that route.
All right, and Ron, if you all could share that with Ron, please. All right, well, I'm glad you're getting everything together in your life. When you get on the outside, you need to continue with that, okay?
Okay.
All right, good luck to you, Mr. Lopez.
Okay.
Norma, you can let them know that L3 can go back. Mr. May, thank you for coming in. Thanks for your patience. Have a good rest of your day and a great weekend.
You do the same, Your Honor.
All right, thank you. All right, and let me see if we have anyone else left on the docket. Norma, Joe Stenberg, what happened with Mr. Stenberg?
I don't know, Judge. I don't know who he's at.
All right, thank you.
I can call him if you want me to.
Yes, please. Or either we can recall his case for.
Is he in?
Did his client ever show up? That's the question.
Let me check.
All right, thank you. And everyone, we're going to take a short recess. Yes, please.
Judge, did you need me to stay on?
All right, we're back on the record in 2019 CR 13789. Could I have announcements, state?
State is present. Finalizing.
Defense counsel present.
All right, the court has received a question from the jurors. Have both parties had a chance to review the question sent by the jurors?
State is reviewed, Judge.
Defense counsel and defendant have reviewed.
All right. The question that has been sent out is as follows. By Texas state law, was he technically outside the store? And it's signed by the presiding juror. The court proposes to send the following answer back. With reference to your inquiry, you now have before you all the testimony, exhibits, and evidence that was admitted, and you are instructed to continue your deliberations.
No objection from the state.
No objection from defense.
With that, we will close the record. And we can go on. We can
Probably a lot prior to. Yeah.
Yes.
All right, for the jury.
All right, everyone, please be seated. Ladies and gentlemen of the jury, it's the court's understanding that you've reached a verdict that is unanimous. Is that correct? All right, if you'll hand the verdict form to the deputy, please. All right, the verdict form appears to be in proper form. If the defendant could please rise. It states, we, the jury, find the defendant Michael Stephen Hernandez guilty of the felony offense of theft under $2,500 enhanced as charged in the indictment. Would anyone wish for the jury to be polled? All right, ladies and gentlemen, you may be seated. Ladies and gentlemen of the jury, as I point to you, I need to know from you whether or not this is your verdict. If this is your verdict, I need you to respond yes. Is this your verdict? Is this your verdict?
Yes.
Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict?
Yes.
We'll start with the back row. Is this your verdict?
Yes.
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 Is this your verdict? All right, thank you, ladies and gentlemen of the jury, so much for your service. Deputy Laura is going to escort you back to the jury room, and I'll meet you there shortly. Everyone, please rise for the jury. Thank you so much. All right, Mr. Hernandez, I'm going to need you to remain in the courtroom. We'll wait for Deputy Laura to come back. All right, everyone, please be seated. Mr. Zimmerman, are you going to be requesting a PSI?
Yes, Your Honor.
All right, your state, are you requesting that the defendant be taken into custody?
Yes, Judge.
All right, so Mr. Hernandez will be taken into custody and we will get a PSI date. I'll get that done as quickly as possible from the court coordinator to get you on a date.
Thank you, Judge.
You're welcome. All right, we can mute. Frank, we can mute.
Here, I'll do it.
All right, thank you. Everyone, just give me a moment. All right, I'm gonna stop live stream. Hopefully everyone has